Hi, it's the Florida Law Guy. Today we're talking about criminal pretrial conferences. If you or anyone you know has an upcoming pretrial conference, this video might make it easier for you to understand what to expect when you go to court. Because most arraignments are waived by criminal defense lawyers by filing pleas of not guilty in writing, the first time most criminal defendants actually appear physically in a courtroom is for something called a pretrial conference. In Tampa, for whatever reason, they refer to them as disposition hearings. But either way, they are basically status checks that judges schedule approximately a month from each other in order to check on a case's progress. Pretrials are generally a circus and courtrooms are packed with sometimes hundreds of defendants. Although Rule 3.180 of the Florida Rules of Criminal Procedure specifically allows a defendant to waive their appearance for pretrial conferences, some judges ignore this provision and require defendants to appear in person anyway. Now, three things can happen at a pretrial conference. First, a defendant's lawyer can announce that the case is ready to be set for trial, and the judge will then set a trial date for the case. Second, the defendant can change their plea from not guilty to guilty or no contest. This is normally done after the defendant and the defense attorney have had a chance to review the evidence, conduct an investigation and further discovery, and have worked out a plea bargain with the state attorney. If the state and the defense are able to reach an agreement for an appropriate sentence, the judge still needs to approve the deal. If the judge does not agree with the plea bargain, which happens rarely, the defendant is allowed to withdraw their guilty plea so they aren't punished by the court's rejection of the deal. Defendants also can plead straight up without a plea bargain with the prosecutor and just throw themselves on the mercy of the judge. This is also pretty rare because pleading straight up can expose the defendant to the maximum penalty and is extremely risky. The third thing that can happen at a pretrial is for the defense attorney to ask for a continuance. The defense lawyer normally explains to the judge that the defense needs more time to investigate and examine the evidence and engage in further plea negotiations before being able to make a decision whether to set the case for trial. In most cases, the judges routinely grant several continuances, depending on the complexity of the case, and will reset another pretrial in about 30 days out. However, eventually, if the judge feels that a case is not progressing and is getting stale, the judge could deny the continuance and set a jury trial over the defense lawyer's objections. It's completely free, so please support my mission to help make Florida law simple for the public to understand by liking and clicking the subscribe button. The way YouTube's algorithms work, the more likes and subscriptions a channel gets, the easier it is for others to be able to find it. So by subscribing, you'll also be helping others. Thanks for watching. See you next time.